Okay. Good morning, everybody. Senate Judiciary. Senator Sears has had to step out for just a moment, but we do have Bryn Hare here, and we're starting with H128. And she can maybe share the screen and give us a walkthrough.
Sure thing. So for the record, Bryn Hare from Legislative Council. Good morning, committee. If you would like me to put the bill on the screen, I certainly can. It sounds like it's easier.
That sounds good.
Okay. I'm just going to pull it up, so give me just a moment.
Okay. Oh, I'm sorry. I was talking to the dogs. Such is the goal of YouTube and Zoom meetings where luckily I'm just talking to the dog and didn't swear or anything.
Morning, Boar.
Good morning.
Good morning. All right, Bryn. Yep, we don't have it shared yet.
Okay.
But we are live.
Having a little technical difficulties with my Word this morning, so I'm just going to share my browser window. So give me just a moment here.
Okay.
Peggy, when you have a moment, will you enable screen sharing for me?
Did the House make any changes in this bill?
From the as introduced version, they did. Yep.
Okay. I have the as introduced version. So.
Yeah, they did make a few changes. Okay, here we go. I think this is it. Okay. All right, can everybody see H128 on the screen? Okay.
Yep.
So this is the version that was passed by the House. It's a relatively short bill. What it does is it adds a section of law to Title 13, the chapter on pleadings and proof and trials. And what the section of law does is prohibit a defendant from raising what's commonly called a gay or trans panic defense in a criminal proceeding. And what the section functionally does is prohibit the introduction of certain types of evidence by a defendant under the defense theory of provocation, diminished capacity, or self-defense. So I'm going to jump in and talk about the specifics here. So in subsection A, first of all, we've got defense based on victim identity is prohibited. And in subsection A, the language here prohibits the introduction of evidence regarding defendant's awareness of the victim's actual or perceived gender, identity, or sexual orientation as a means of excusing or justifying the defendant's criminal conduct, or of establishing a finding of defendant's diminished capacity to form the requisite mental state to have committed the crime. So I thought I would talk just briefly about diminished capacity. This committee, I'm sure, is pretty familiar with this, especially as you've been working on these issues in the last few years. But just for the record, diminished capacity really just operates to reduce the degree of the offense rather than excuse the commission of the crime. So it can be relevant to a variety of claims. A defendant may claim, for example, that they suffered from a diminished capacity to form the requisite mental state that's an element of the crime that they've been charged with, or that because of that diminished capacity, they could not form the requisite mental state. So the relevance here of diminished capacity evidence requires an examination of what the mens rea element of the charge is. So when, for example, specific intent is an element of a crime, evidence of some kind of diminished capacity may be introduced to show that the defendant could not have formed the requisite mental state, and therefore couldn't be successfully prosecuted under that charge. So another example is in the homicide context, diminished capacity is recognized as a mitigating circumstance that may reduce a killing from murder to manslaughter, just as an example. So that type of evidence that's described in subsection A can't be used as a defense to the criminal conduct, can't be used to establish a finding that the defendant suffered from diminished capacity, or to justify a defendant's use of force against another person. And then I'll move on to subsection B, which sort of has a similar types of evidence that can't be introduced. So this subsection prohibits the introduction of certain evidence to mitigate the severity of a crime. And that evidence includes evidence of a nonviolent sexual or romantic advance by a crime victim towards a defendant, or evidence of defendant's perception or belief, even if it's inaccurate, of the gender identity, or sexual orientation of their crime victim. So those are the two types of evidence that cannot be introduced to mitigate the severity of a defense.
Can you explain number one?
Evidence of a nonviolent romantic or sexual advance.
Yeah.
So that's that would be a situation where a defendant couldn't introduce the fact that their crime victim made a romantic gesture towards them, or maybe touched them in a way that was a sexual advance, as long as it was not a violent touching. So that type of evidence can't be introduced as an explanation or a mitigating circumstance for defendants, or to justify defendants' criminal conduct against the victim.
Yeah, I'd really like to look at, maybe I'm reading more into that than there's there. But
Yeah, I have a question about that same piece. If so, what we're calling a nonviolent romantic or sexual advance, suppose that were itself nonviolent but criminal. So in other words, if a touch was on a part of the person's body that was, their genitals, let's say, but it wasn't violent, isn't that still a crime?
Or are you thinking, so you're thinking of some kind of assaultive behavior, essentially, unwanted?
I suppose, yeah. So when I read it, when you said sexual advance, I took that to be an advance that was not crossing the line into itself being criminal conduct or unwanted touching. Can you just clarify that?
So I think that the intent of that nonviolent language is to clarify that the type of conduct by the victim could be unwanted sexual attention or romantic attention, but it can't be assaultive. I think that is the intent, that it can't be assaultive touching. However, I agree that the word nonviolent may be encompass a narrower category of conduct.
yeah, I don't,
So,
but I just, well, a person, whether they're gay, straight, or trans, or whatever, makes a romantic gesture to another person, grabbing their genitals, groping, whatever, and the other person pushes them away. Does that mean the other person who pushed them away could be charged with assault and can't use the defense that they were being groped?
yeah, could I add to that, Senator Sears?
Sure.
So I guess I need to hear from some of the witnesses about what this means, but it does seem to me that it doesn't even have to be a groping thing. If it says sexual or romantic advance, I think that's the word that's used, that if if somebody is pestering you and making advances, even if it's just verbal and you shove them away, shouldn't you have the right to do that? Or you sock them? Or, I mean, are we saying that you can't, even if somebody is making advances to you and you respond to that, that then I can't use that as a defense? Well, he was coming on to me and he was being very aggressive and I just socked him.
I'd say
I mean, is that,
Donald Trump was coming after Senator White. We know what he said he's done. She couldn't push him away.
Well,
I guess I need to hear from some witnesses because this doesn't make any sense to me at all.
yeah, I think definitely we need to look at that more, because I also, in my mind, am turning around all of the sexual harassment language that we've been asked to internalize and think about, and so you are not allowed to make a sexual advance to somebody and touch them. It's not okay. It's contrary to policy, law, guideline. But here it seems like, at least as written, it allows the possibility that someone can do that, but then that can be brought forward in the discussion of the crime.
I just want to make clear, I don't have a problem with the scope, with the intent, as I understand it, of the bill. I thought it was kind of that Matthew Shepard type case out in Wyoming where he was violently murdered and left to die on a fence, as I recall. And that that defense that he made advances to them is just not justifiable. But I'm just concerned with the language that I'm seeing in B1. That's right. The word nonviolent is troubling in this context. So I just want to make that clear to anybody listening on YouTube. And I don't think there's anybody on the committee who certainly not support the intent of the bill.
So this was apparently pared down from the original, this section. So it'd be good to know what their discussion was. Can you fill us in on that, Bryn?
Yeah, so the from the as introduced version, the bill removed some language about reporting, which was, I think, in subsection C, and that was placed in another bill. And
well, even B has been pared back.
Yeah, I'm reading B from the original version.
so
A nonviolent, romantic, or sexual advance by a crime victim or a defendant's perception on or behalf, even if inaccurate, of the gender identity, or sexual orientation of a crime victim shall not be used to mitigate the severity of the offense. It seems to be much more, seems clearer to me than the language that we have now in B.
So the House members felt that the language in B in the version as introduced was confusing. So the language that you see here in the House passed version essentially just breaks up that original subsection B into a couple of subcategories. So it's intended to make it, and there was also some addition of the words crime victim towards the defendant. There was some clarity put in there about whose sexual advance we're talking about. So they were concerned that it wasn't clear in the as introduced version that it was actually the crime victim's sexual advance towards the defendant that was intended to be excluded here. So I would say the idea of the House was just to make it clearer. I don't think it was intended to change the scope of it at all.
Well, like Senator Benning,
Brennan, I may just not have my brain properly engaged this morning, but did this begin as a jury instruction?
No, it was introduced as this standalone section of law in Title 13 that talks about what evidence is not admissible to be raised as a defense.
Because
It was never introduced as a jury instruction.
don't we have a bill pending on the so-called gay defense? It seems to me this concept began as a result of a California bill that came out that would prevent or would enable a jury instruction regarding somebody trying to use a gay defense. And it seems like this germinates from the same concept.
I think it's called gay panic defense.
Gay panic defense, thank you.
Yeah.
I don't know, I'm joining in the concern about what I'm reading here.
Why don't we listen to the witnesses and maybe they've got some information for us on the genesis of this, but it seems like to me anyway, in clarifying B1 and 2, the original, they've even made it's more difficult for me to understand. I don't understand.
Yeah, for me, it's the phrase sexual advance. If it was a nonviolent romantic gesture or something like that, that's clear that that conduct is in itself legal or inoffensive. But when you get into sexual advance, then it seems to muddy the water in terms of who is committing a crime.
Is groping considered violent? What's a non-violent? I think that may be a better way, because I mistakenly said that groping might not be violent. That would be violent. Would it not?
Right. I think that's a question that the court would have to decide in a case like this, whether or not groping would be considered
I would think it would be considered violent. So I need to understand what would be non-violent. A kiss on the cheek?
Again, I think that it would be up to the court to decide based on the circumstances of the situation.
I mean, pre-pandemic, you're sitting at a bar and next to someone you don't know and their knee touches your knee. That'd be might have just been by mistake, but would that be a nonviolent romantic or sexual advance? Would that be seen as that?
Well, I think in some ways what this is trying to speak to is the moment where someone realizes that a person of the same sex has a sexual interest toward them, and then they react violently for reasons of their own and commit a crime against that person because they now understand that they are interested in them.
Yeah.
And that I get and that I support, but when it speaks about a sexual advance by the crime victim, that's pretty broad language. So
Can I ask a question about that, Philip?
Yep.
Maybe I'm not reading this right, but I don't see anywhere where it says that it's a person of the same sex that makes an advance toward you.
No.
In B,
Yeah, I agree, Jeanette.
it doesn't say that at all. It just says that you can't use as a defense that you thought someone you questioned their gender,
Sexual identity or gender identity.
or that they. I don't see anywhere in here that says it's the same.
No,
sex.
I agree, but if it was let's say a man a man,
If a man is pestering me at a party or at a
Right.
bar or on my street or in the park and is trying to make advances toward me, I have every right to sock him in the jaw.
but you wouldn't use a defense that you realized his sexual identity.
No, but
As a
it doesn't
defense.
say sexual identity in
or
B.
it says
B1.
perceived, well, the up above in A, it
Yeah.
says perceived sexual orientation or gender identity.
Right, but B is a separate one, so it doesn't say that.
It's almost done. As I read it, A does everything the bill wants to do.
Right,
And they took out the report and they changed B as we see here, but I'm not sure B as introduced was even. Is this model legislation, Bryn?
It is based on model legislation. It's not a replica of the model
And
legislation.
have other states, what have other states done with B?
So other state, I think that the part in B that is significant is the idea that what Senator Baruth talked about earlier. There are many examples of criminal defendants raising as a factor in attempting to mitigate the severity of the offense that their crime victim came onto them and it was unwanted. So that's what B is trying to address. I hear the committee's concerns that it's not clear that it's not narrowly tailored enough. So I think that there's, we can flag that for as you work on this bill.
Yeah, okay, thank you.
But I
I
can
think-
send the committee a list of other states that have similar legislation, so you can
Okay.
check out some
Can
other.
we, yeah, but when we get to markup, I would like to look at other state. I thought this was gonna be a simple little bill. I was ready to vote it out today. But I guess nothing, you should never think that here. I would love to see how other states have dealt with that, and I understand that problem. If I perceive that if 77 years old and I perceive somebody's coming on to me on the cruise ship on the shuffleboard board, that I can understand that and what they're trying to get to, but I'm not sure they get where they want to get, and I just don't understand it. So anyway, with that, I think I would. Are there any other questions for Bryn? Bryn, thank you very much for trying to bear with us on this. And
So I'm going to disable my screen sharing now. Is that all right?
yeah, please. And our first witness is Bor Yang, the Executive Director of the Vermont Human Rights Commission.
Thank you. Thank you for having me here today.
Thank you for being here.
Yeah, I really enjoy showing up in front of this committee, and I haven't had a chance to, I think, this
No.
session yet. Maybe I'm avoiding you or you're avoiding me. I can't figure it out, but in any case.
I think you're avoiding us because you're always welcome here.
I do just want to say that, as you all know, the HRC enforces the anti-discrimination laws of the state, and sexual orientation, gender identity, and sex are protected categories, but we don't prosecute or defend criminal matters. And so while we do strongly believe and defend the human and civil rights of LGBTQ plus community members, and that's why we support this bill, you all have asked some really great questions that I want to defer to prosecutors and the Defender General's office and other private attorneys who work in this area to really answer your questions about specific language and how that would be interpreted and how they would interpret it. And I think that would only be fair. I think that as a matter of principle, the intent of this bill is good and one that definitely should be honored. And I certainly hear the committee saying that they understand that. I want to start today with just a couple of a few stories. The 1954 murder of William Simpson in North Miami, Florida. The defendants had claimed that they shot Simpson, who was a gay man, because he had made them feel unsafe and had made unwanted sexual advances towards them. And the term pervert was used to describe Simpson. There was a lot of credible evidence that the defendants were criminals, that they had frequented the area of the highway to rob drivers, and in fact had intentionally targeted gay victims. But because they were able to bring up Simpson's sexual orientation, to really put his sexual orientation to play it as a pivotal point, the defendants were convicted of manslaughter rather than the greater first-degree murder, even though he had been targeted. Most of us probably remember the Jenny Jones case in 1998, when Scott Amador revealed that he had a crush on Jonathan Schmitz while on the Jenny Jones show.
Yep.
After they spent a friendly evening together, Amador left Schmitz a note. The defense used the note and Amador's homosexuality as a basis for Schmitz panicking and then killing Amador. And Schmitz, again, was convicted of the lesser offense of second-degree murder rather than first-degree murder. And then in 2015, Daniel Spencer, a guitarist, had invited another musician, James Miller, to his apartment to play music together. Later that night, Miller stabbed Spencer 4 times and killing him. And Miller then cleaned the apartment, went back to his home, changed his clothes, called the police. And the defense attorney argued at trial that because Miller had never been in trouble with the police before, the only thing that could explain him committing the murder was that Spencer was gay and had tried to sexually assault him. But there was no evidence of this whatsoever. And the jury convicted Miller of criminally negligent homicide, the lowest grade of felony in Texas. And ultimately, Miller was sentenced to only 6 months jail term and a 10-year probation sentence. What is really alarming about the crimes and the violence that occurs against LGBTQ victims is that they tend to be really egregious. We know that the murders of LGBTQ victims, guns are used only about 26% of the time, whereas they're used about 46% of the time in other majority of homicides. And in a lot of these crimes, victims are stabbed multiple times. And so they're very violent. H-128 is, the intent of it really is to remove the gay panic defense. And what you're really doing is removing a legal strategy that is rooted in homophobia. The reality is that the sexual or romantic advances of someone who is or who identifies as LGBTQ is really no different from that of someone who is cisgender or straight. And I always, sometimes it's helpful to sort of compare it to a different protected category. The reason why we want to get rid of the gay panic defense is the same reason we would want to not permit, let's say, a white woman to say, who is a criminal defendant, to say, when this Black man came towards me and left me a note and wanted to date me, it scared me so much that I then stabbed him multiple times. So the idea is that that's really offensive to our society, that the idea that this person, because they're Black, that permitted you to be so out of your mind, and that you weren't making sense anymore of the situation. And that's why you acted the way that you did. And so it is pretty homophobic, and it's based on stereotypes about people who are LGBTQ and their actions. And also the gay panic defense really is removing the burden and the blame from the offender to the victim. And so the bill is really seeking to get rid of that. I want to also say that while I'm not a criminal attorney, I do think it's sort of important to highlight that we exclude evidence on a regular basis as lawyers. The courts exclude evidence on a regular basis. The entire rules of evidence are rules of exclusion. We exclude relevant evidence because it's hearsay, or it's not the best evidence, or it's subject to privilege, or we say it's overly prejudicial. And sometimes evidence is even excluded from the jury because the lawyers delayed and they missed deadlines. And so sometimes they miss disclosure deadlines, and the courts might even exclude evidence that is otherwise relevant. And so the Vermont legislature and you all are really not asked to remove a defendant's legitimate defenses here, but really to take a stand that someone's sexual orientation and gender identity is not a legitimate defense. In the United States, LGBTQ plus people are disproportionately targeted. They make up only 3.5 to 5.6% of the population, but hate crimes against people based on sexual orientation or gender identity make up about 18.8% of all hate crimes. 1 out of every 5 lesbian, gay, and bisexual people living in the United States will experience a hate crime in their lifetime. 1 out of every 4 transgender people will, and transgender women of color are especially vulnerable. Between 2013 and 2017, of the 102 known transgender people killed in hate crimes in the United States, 75 were Black or African American. And juries have acquitted dozens of murders because of the gay panic defense or mitigated it as well. And so based on principle alone, the fact that we regularly exclude evidence that we don't think is pertinent, the Human Rights Commission supports this bill, and we would encourage you to do that. And whatever you have to do in terms of speaking to other witnesses, in terms of crafting the language perfectly so that we respect the rights of a criminal defendant, but also really the human and civil rights of a victim who is LGBTQ, I think would be great. And if Vermont were to pass it, we would be among the 9 states, including Connecticut, New York, Rhode Island, and New Jersey, to pass a similar bill. So I encourage you to do that. And I'm happy to answer any questions that you may have. Thank you for your time.
Thank
Mr.
you.
Chair.
Yes, Senator Baruch, and then Senator Benning, I believe.
Boer, thank you for that. And I agree with everything you said. So if I could, I know you want to defer to prosecutors in terms of interpretation of the language, but I know that you deal a great deal with sexual harassment, and you have instructed, many groups on rules on sexual harassment. I'm wondering, does that section in B strike you as at all problematic? The idea that a sexual advance cannot be introduced as evidence, because it seems ambiguous to me whether or not that sexual advance itself crosses the line into sexual harassment or criminality, and that puts me in a position I'm not comfortable with saying, well, in this subset of cases, we'll put aside everything that we think is right about sexual harassment or unwanted sexual advance and have a blanket prohibition on presenting evidence of it. Any thoughts on that?
I do appreciate hearing the conversation about language that's in section A, that is missing in section B, and that one could interpret it to be broader than what is intended. So I think Senator White, you had brought that up, and I hear you on that. I don't find it ambiguous only because I know the intent. And as lawyers, when there's any ambiguity, we go back to the legislative intent. And the idea behind that section is that if someone, just because it really is about the identity of the victim, right? And so that we're still trying to just remove the fact that someone is gay or that you perceive them to be gay or transgender. And so that the nonviolent sexual advances of someone who's straight or cisgender should be treated the same as someone who is gay or transgender. That is the legislative intent behind that. So because I know the legislative intent, because a lot of these conversations were happening in the House committee and also happening right now, is that to me, it would be clear how that should be interpreted. But I mean, we're talking about the lawyer down the road 20 years from now who may, or a judge who may not be privy to all these conversations, who might read this and say, so if they read this and they go, oh, that's ambiguous, then they would go to the legislative intent, they'd look at all these conversations, and I think it would clarify that point. But the possibility does exist, and we know this as lawyers, is that a judge or would read it and go, it's not ambiguous to me. I don't have to go to the legislative intent. And so this is how I'm going to treat it. And so I certainly think you could certainly clarify B the way that A seems to be very clear about that. I can't imagine that would be problematic. But again, I wasn't privy to all the conversations and why that occurred without that additional language that we see in A. And so I just want to be respectful of other people who really have the expertise in criminal law on how they would interpret that. But I hope that answered your question, but also respectfully defer to the people who are experts.
It did. Thank you.
Senator Benning.
So Bohr, after 37 years, some would say I know a little bit about criminal law. I don't read B as having anything to do with sexual orientation. And in my eyes, there is two cracks that the prosecution would have at trying to prosecute someone. One is at the trial level, where an argument could be made, you don't have the right to bring any evidence whatsoever to talk about evidence of a nonviolent romantic or sexual advance. The second is when you're being sentenced, the judge would literally statutorily be prohibited from using that aspect as any kind of a mitigation in sentencing when they're balancing aggravating versus mitigated circumstances. So I'm concerned. You did say that there were 9 other states that had similar language. Do you know of any of the other states that have mirror language?
I don't. I didn't compare that. I do want to say that B does show up under the heading of victim identity. And I don't have it in front of me right now, but when Bryn had shared it, the heading is victim
It's
identity.
defense based on victim identity prohibited.
Yeah. So, as lawyers, we are reading these things in the context of the headings and the other parts of the bill that are connected to it to compare to. But I want to go back to Senator White's position is when you remove language in one section but keep it in another section, that suggests that was done intentionally. So you do want to be careful. So if you really intend A and B to match, then you just put that language back in. And so I think that's important too. But the fact that the heading is clear means that we're not just talking about removing anybody's legal defense here as to nonviolent sexual advances here. We're talking still about the identity of the victim here. So it's not as open-ended. That would be my opinion.
Well, I'm going to
Appreciate that. And I
just if I could respond.
Yeah, I understand, but she kind of has said she'd prefer to have the prosecutors and the defense attorneys on this particular issue. Go ahead, Joe.
No, I can wait. That's all right.
No, I don't think you have to. I'm not trying to cut you off.
I'm trying to think in the mind of a normal defense attorney. What crafty way would those nasty prosecutors figure out some kind of a response to a defense that has been presented when, let's say, a fight begins as a result of a sexual advance by one person on another? Would a prosecutor be able to slink in evidence that the individual who was the perpetrator has just learned about the sexual identity of the other person, and then all of a sudden make an argument that they could nullify any defense at all? I mean, that's the way my brain is functioning right now. I'm trying to think of how nasty a prosecutor would be with this statute on the books.
I'm sure they can be.
So I agree.
Prosecutors can be nasty.
Well, I see there's none of them on the screen yet, so I'll tell them that to their face when they get here. But I'm just trying to roll through my head, and I'd be very interested if there are any other states that actually have language that mirrors this provision and how it's been interpreted in the past.
I think Bryn will take a look at that for us. I would also point to the language that says, even if their perception is inaccurate.
Yeah, there's a lot of ways to play with this language in a courtroom, and I'm trying to scope out where it would go.
Senator Bohr, did you have a response to Senator Benning, or did you want to make one? I think you've already been pretty clear.
Yeah, I don't have a response. But yeah, I don't.
Senator Nitka.
So I was just going to say there was a case in Vermont many, many years ago, more than 20, in Pulteney, where a young man, early 20s, was at a bar after work, and someone else was there, an escapee, so to speak, from the Albany, New York Psychiatric Center. And on the worker's way home, he was killed by the escapee, who had been in the bar also, and said that he perceived him to be gay. It wasn't that anybody saw any, I don't know whether the fellow was or not, but in fact, the defense was he thought he was gay. And, it was obviously a warped mind, but that case did go to trial. And I don't know the results of that. I think the fellow was put into a psychiatric center again. But so there is that case where that happened here. So I think, it's hard to sort out the fine line here, I think. So I guess maybe we'll hear more.
I mean, I think the idea was that at some point in our history, the fact that someone of your same sex is making any kind of sexual advances towards you justified you being so alarmed that you acted in a way that is contrary to what you would normally do. And that's why it was being used to acquit people and mitigate sentences. And the goal is really to say people's sexual orientation and gender identity is just not alarming. And we don't allow you to use that as a basis for you to act outside of what you would normally do when anybody makes a sexual advance towards you. And so I think you can craft a bill that respects that. I certainly think it's very possible that you could pass that. And I think that we all in this virtual room and everybody who's watching agree that we have to get rid of this idea that you can defend your violent actions because the victim is gay or transgender or you perceive them to be that. And so to whatever extent you can do that work and pass this bill to sort of respect this community and the hate crimes that is happening against them, I just would encourage you to do that. And so
appreciate that. I think that's a good thought. Thank you so much for being with us this morning, and good to see you. I didn't realize it's Happy New Year since we hadn't seen you, and here it is.
Yeah, that's true. Yes.
Usually we get to see you frequently.
I know.
Well, thank you.
Take care of you.
Hopefully
Take care of yourself.
sometime in the near future, we'll see you in person.
Yes, I hope so too. Be
That
well.
lead- Thank you. It leads us to our next witness, Kim Jordan, who's the director of Safe Space Anti-Violence Program with the Pride Center of Vermont. Kim, thank you for joining us this morning. And I think you've heard some of the disagreement, but I do want to emphasize that I think the committee is committed to the bill and the concept of that there should not be a defense based on the victim's identity. And so I think we're all with the concept. There's the way it's worded is where the problem is. So I hope you don't think that we're not supportive of the concept and of the goals of the bill.
Thank you.
Thank you.
Thank you. It's an honor to be here. I'm in my second week as director of the Safe Space Anti-Violence Program at the Pride Center of Vermont. And I am happy to be here. I will share some testimony, and then toward the end of my testimony, I'm going to speak specifically to your questions of this very rich conversation that I've been witness to. Thank you. Good morning. And for the record, my name is Kim Jordan. My pronouns are she, her, and I am the director of the Safe Space Anti-Violence Program at the Pride Center of Vermont. At the Safe Space Anti-Violence Program, we support and advocate for LGBTQ+ Vermonters, that's lesbian, gay, bisexual, transgender, queer questioning, and other folks who fall under the umbrella, gender non-binary, gender non-conforming, and this also includes HIV positive folks. Vermonters who have experienced violence and or harm. And I'm here today in support of H128. In 2018 and 2019, an average of 43% of survivors who accessed Safe Spaces services experienced hate violence. And this statistic does not include intimate partner violence. At Safe Space, we notice that hate violence is most often perpetrated by neighbors, landlords, and employers. This trend has increased during the COVID-19 pandemic. And in the past 3 months, 55% of survivors who accessed Safe Space services reported experiencing hate violence in Vermont. And hate violence can range from active discrimination to a hate crime. Reported incidences of hate violence have increased in the past year, and so too has the severity of cases. Our Safe Space advocates have noticed that the level of aggression and fear from these incidences has significantly increased as well. We don't yet know the full impact of the pandemic on survivors of violence, but what we are seeing is that people who experience harm are in more constant proximity to those who cause them harm, and that fewer options and alternatives are available to those in need of safety and support. In addition to the everyday stressors of living in a global pandemic, this has caused tensions to escalate more rapidly than in the past several years. On a national scale, the LGBTQ+ community is witnessing and experiencing the same escalation of tensions and violence. Trans people, and specifically trans women of color, have been fatally victimized at an increasing rate over the years. 2020 is considered to be one of the deadliest years on record for trans and gender nonconforming people. This is an epidemic that disproportionately affects Black trans women who, according to Human Rights Commission research, comprise 66% of LGBTQ+ victims of fatal violence in the United States. Anti-LGBTQ violence is increasing nationally and in Vermont. It goes without saying that this is a concerning trend that impacts our LGBTQ+ communities and people who are perceived to be LGBTQ+. And while the LGBTQ+ panic defense has not been used in Vermont, our state is not immune to fatal violence. In 2016, Amos Beatty, a trans man, was violently beaten to death in Burlington. Fatal violence has, and unfortunately may, happen again here in Vermont. Too often, our marginalized communities need to experience incredible trauma and violence in order to receive legal rights and protections. Passing this bill now, in a time when violence toward LGBTQ+ people is reported to be at an all-time high, would signal to our communities that Vermont recognizes the increased threat to the safety and lives of LGBTQ+ Vermonters, and that violence and hate are not tolerated nor excused in our state. And regarding today's conversation about violent and non-consensual touch, I'd like to highlight that non-consensual touch falls outside of this bill and is a larger discussion about consent laws. This bill is covering that if someone is simply hit on by someone who is LGBTQ+, that person cannot then assault the LGBTQ+ individual because they are LGBTQ+. Thank you, and I am open and interested in questions and dialogue.
Thank you. Any questions for Kim? Thank you for joining us this morning, Kim. Senator Baruth has a question.
Yes.
I wouldn't say it's a question so much as, thank you for your testimony, Kim. I appreciate it. Non-consensual touch is where my concern lies, and it's really one phrase in the bill, which is sexual advance, and it may be cleared up immediately by having a prosecutor or an attorney explain. It also, I think, is modified by nonviolent. So nonviolent sexual advance. I just don't know how much that includes. So, you know, I want to make sure that we're not inadvertently somehow confusing what we want always to be a clear message in the law, which is that non-consensual sexual touching is not okay and will be dealt with. Again, it's not a question for you. I'm just explaining my own single concern about the bill so far.
Of course. And I mean, your question is a question that has happened on a national scale and happens every day about, well, I thought you wanted it. No, I didn't want it. I didn't say I wanted it. Like, these questions are happening all the time. And I want to illuminate the concept of intent versus impact. Earlier, the example was brought up about if my knee brushes someone else's knee, is that one unwanted sexual touch? And if it was unintended, no, that's not you know, non-consensual. There can be an oops, I didn't mean to do that. What we're talking about Section B, I want to highlight the word mitigate. So if this was unwanted sexual touch in a way that someone would want to take legal action against the person who perpetrated those actions, this bill would not be a component of how the charge went. For example, if the person who made the unwanted sexual contact presented as or identified as LGBTQ+, the person who received that contact cannot say, well, it's because they were gay and I don't want to be seen as gay, or I panicked and I had to shoot that person because they made that non-consensual touch. This would not allow a plea, right? Pleading down, as the example that Bohr offered earlier. It wouldn't go from homicide down to manslaughter because the person who caused the violence to the LGBTQ+ person panicked. So whatever the regular cycle that the court process might take, it would not be dependent on whether or not the person who caused violence in return to being perceived as wanting that touch by an LGBTQ+ person. This gay panic bill would alleviate any mitigation of what that charge might be.
Senator White.
So I just need to make sure I understand. So that somebody makes advances toward me, and regardless of who the person is, and I sock them because I didn't want that, and they kept on, just not even touching, but just I can, I can be charged with stalking them, and I can use the defense, but they were making advances toward me, but I can't use the defense that they were making advances toward me and I thought they were gay. Is that, because I certainly can use as a defense that they were making advances toward me, whether they were the same sex as me or not, but I can't use the defense that I acted that way because I panicked. Okay, great. I just
That's
wanted to,
true.
okay.
But
And as
But,
Gore
uh,
shared, I'm sorry.
but on the other hand, even if you don't mention that, would say that it was, yeah, okay, go ahead.
Because I
understand.
might just not want the advances.
Right.
Whether I thought the person was gay or straight or trans or
Well,
whatever.
that's
I just,
that's where the issue comes. I guess the word
Yeah.
mitigate is clear, but on the other hand, would it be seen as,
but I can't use the defense.
can't use a defense you thought they were gay, you could use the
Right.
defense if you didn't want the advances.
Well, I didn't want
Well-
any advances from anybody.
Mhm.
What,
But it seems like it would be
that's where
impossible to
that's
separate
where our
out.
different, right, that's where our different, that's what our
Why
concern.
would it be impossible? If I
Well-
don't use that as a defense, if I
Well-
just say, I didn't want that advance, but I don't even mention that the person that I thought, that I
Well-
panicked because I thought the person was gay. I just didn't want the advances. So I'm not using that defense.
No, understood, but let's say that, that in the example you gave, I think that there was people of opposite genders. Let's assume
Or
it was,
same.
well, let's assume it was the same. And you said, I didn't want that advance.
Right.
The court might invoke this provision and say, you can't use that defense.
But I didn't
Right,
bring
right, but
up
they-
that defense. I just didn't want the advance. I
Right,
don't
but-
know why.
But you wouldn't be allowed to say that in court.
Why wouldn't
because-
I?
Well, because then you're making a defense.
I'm making a defense that I didn't want the
Okay,
advance, not that I didn't
can
want
I
the advance because
suggest
they were
that
gay.
look, I think this section needs work, no matter whether or not, I understand the goal of it better, thank you to both witnesses and as well as Bryn. I understand the goal of B. My question is, does B work as intended? That's the question, and I think that's the one that Senator White and Senator Ruth are currently raising, and I tend to think that it could be wordsmithed better. But we'll wait for the prosecutor and the defense bar to weigh in. Senator Benning, questions for the witness?
Well, actually, I was going to say to the witness, can we actually have a bill in committee? It's S58, which was targeted directly at the gay panic defense and doesn't go as far as this language does, because I think this language has muddied the water. I'd be interested to see if you can look that up and get back to us and see if there is something you see as wisdom in S58 as opposed to this bill. But I would encourage the committee as well to take a look at S58, because I think it speaks more directly to the problem and doesn't get us into this muddy area of what do you mean by X, Y, and Z. That's all. Thanks.
Thank you. Any other questions for Kim? Thank you, Kim.
Thank you.
Our next witness, Rosanna Davis. Welcome back. I think it's her first time this year.
Actually, Mr. Chair, as she's coming on board, I just want to say that she's a witness to why I was late yesterday. I was not out riding my motorcycle, so
Oh, it's her fault. Is that your defense, Senator?
I'm so sorry. Have we gotten to me? I missed the part where you said the person's name.
Yes, we have. Thank
Oh,
you.
then hello.
Hello.
I was
Welcome back.
reminding Susanna that you were my witness for why I was late to committee yesterday. We were
Yes,
both on the same
we have
panel.
an alibi.
Well, trying to claim that's why he wasn't riding his motorcycle, and Facebook posts of him riding his motorcycle.
No, he was on the panel, but riding on the panel.
Okay.
Right.
Thank you. H128.
Yes. I first of all, I want to apologize. Well, no, first of all, for the record, Susanna Davis, Racial Equity Director for the state. I do first want to apologize for being late. I was in another committee, but since the time that I joined here and caught the tail end of Bohr's discussion and the testimony that you just heard, I suppose what I'd like to ask you is what can I contribute to this discussion that you haven't already heard, because I don't want to tell you things that you've already heard. I think that the provision we've been discussing is an incredibly important one. It encourages people to grow up and to relieve themselves of antiquated views about what's considered acceptable behavior in a society that has moved past its regressive viewpoints about some historically marginalized communities. You all have heard the data today about trans women of color who are specifically at high risk of assault and murder. And you've heard about how there are deeper racial disparities within a lot of the other disparities that we experience, not just in criminal justice and not just for the LGBTQIA+ population, but in general and in general social dealing. So this particular bill would be an important step in helping to reduce some of that by removing a defense that is effectively a cop-out from a bygone era. So I'll leave it there, but I just, I don't want to ramble at you with things you've already heard. So I'd like to contribute in a way that's actually useful to you.
You're muted,
What you
Dick.
just said, actually, what you just said that regarding a regressive and bygone era, that's actually that may be all I needed to hear. But Senator White, do you have a question or a comment?
No, I don't have a question, but I was just going to comment, Susanna, I think I heard you say that we just need people to grow up. That is a tall order.
It is.
It is.
It is, yeah.
And yeah, do you have a sense of the Vermont scope of the Vermont problem here?
I don't, and it's for a couple of reasons, and it's reasons that you all are familiar with, largely data. When we talk about race, when we talk about gender identity and expression, and when we talk about assault and harassment, these are often things that go unreported or underreported. And when you intersect those things, it's even more difficult to track how often this is happening, where it's happening, and to whom it's happening. So one thing that we can do is extrapolate a bit from national data. Vermont, in a lot of ways, looks like the rest of rural America. And so if we look at jurisdictions that may have a little bit more clarity in this reporting, it would be a good place to start to consider ourselves probably on par unless we can prove otherwise. I know that's a strange approach to data management, but again, we're talking about consequences that are very much life and death. And so in some respects, it makes sense for us to be prepared for the worst end of the spectrum. Now, I know Vermont tends to have a reputation for being inviting and open in a lot of ways, but we've seen over the last handful of years when it comes to things like race or age, that's not necessarily the case. And so being able to confront some of our biases on issues like these is going to be really important. We're also in the middle of a national and international reckoning on sex, sexual violence, harassment, and all of what that entails. I often find it really strange that a lot of the same people who defend gay panic defenses are often the same people who say, well, you can't say anything to a woman these days anymore because now it's harassment. But somebody says something to you in a bar that you didn't like, and you deck them in the face and use gay panic as a defense. So, you know, there's a certain level of consistency that this bill seeks to attain. And, you know, again, this is one way to curb certain disparities and also to bring our governance to 21st century.
Appreciate that. Actually, that's very helpful to put in perspective. And I think too often Vermonters look at things as it doesn't or can't happen here. And when we hear that frequently when something happens, and when I was first elected that year, there was a murder in a factory where someone went in with a gun and shot up the factory and murdered the plant manager. That was the Eveready plant in Bennington. And, you know, and then as we heard more and more about these types of shootings, I kept hearing that it can't happen in Vermont, but it already did. Leave it there. Senator Benning has a comment or question.
Probably both. The title of this act, and forgive me for looking up because I'm looking at a different screen. The title of the act is Defense Based on Victim Identity Prohibited, but it's limited to sexual orientation and gender identity. As I sit here thinking about it, the number of murders and assaults against people of sexual orientation or gender identity that may be different than the defendants, as horrific as they all are, the numbers overall pale in comparison to the tens of thousands of white defendants, especially in the South, who were let go by an all-white jury for having murdered someone of color. Is this an opportunity to broaden the category of victim identity and cross all spectrums of, say, the protected classes? I'm just throwing that out there as something to consider, because as I think about it, this bill is very targeted to one specific class. And maybe this is an opportunity to make a public statement for society moving forward that this activity of giving a defense of any kind just based on whatever the protected class may be is not appropriate. I'm just interested in your reaction.
Yes, Senator, this is definitely an opportunity for that level of expansion. It's an overdue one. We know already, as you said, even those who were brought to trial for assault, for example, in the South or in other parts of this country, for racially motivated attacks, often were let off. We know that a lot of people lied. We know that Emmett Till's accuser lied and recanted later. Not that that brought back that 14-year-old boy, but it was clear that all you had to do was allege a harm that may not have been an actual harm, but a social harm and a perceived violation of some social order that we made up after we murdered the people who lived here already. Then we set up a system of moral laws that suddenly everyone had to follow and crafted our behavior around those rules. So it is absolutely that opportunity. Again, as a couple of other witnesses have already explained, while this bill is very focused on one group of people, that is people who are considered, and I don't like this term, but sexual minorities, people for gender expression and identity, we know that proportionately it's often trans women of color who are experiencing the brunt of this. And so in that way, there's very much an intersectional importance here between race and membership in LGBTQIA+ community. Also, I think, it's tricky in the United States, right? A lot of our affirmative defenses do hinge on victim identity, right? For example, I was being attacked by a person who was a 6-year-old child. Jury's not going to buy that, right? But if I tell you I was being attacked by a person who's, 450-pound bodybuilding male, it's something that a court or a jury might find more believable. So in some senses, the identity of the other person is taken into account. But what this bill does is draws a more bright line about when that's acceptable and logical and when it's just nonsense, right? So if I'm being attacked by a person who's triple my size and who may be a professional, a martial artist or something, it's very different than if a person touches my shoulder in a bar and is of the same sex that I am, right? And so it's an acknowledgement by the state that there are some perceptions of threat that are clear, and in law we have the reasonable person standard, right? There are some perceptions of threat that are considered logical and objectively correct, and there are some perceptions of threat that are based on antiquated views about who's allowed to talk and flirt and think and lie and when and where.
I think if I might, Joe, suggest that if we wanted to go and broaden the bill, that what we should do is put some words in about a report back from various groups on whether or not other groups should be added to this, rather than trying to broaden it. I don't know that we have time left in the session to do that and do it correctly.
No, I think I tend to agree with you, Dick. The fact is, if I was murdered and somebody was to use my identity on the basis of defending themselves in court, it seems that this bill offers us an opportunity to give the judge the ability to say, ladies and gentlemen of the jury, you may not use Benning's identity as a rational way of coming to a verdict.
What if I was afraid of motorcycle gangs and you have your black jacket and I don't, and I perceive because you've got that jacket that indicates you're a member of some motorcycle gang, and I'm afraid of motorcycle gangs. And are we adding that I can't use that as a defense? That I thought you, from a distance, you looked like a Hell's Angel.
I don't want to
on your Harley.
Minimize, but I don't want to minimize BIPOC or.
I'm not, Joe. I'm suggesting that when you broaden something,
it's worthy of a study and a report back. I totally agree with you. Your example is one that does touch on me in a weird way, because wearing those leathers, there have been several occasions when I go for a ride around the country where literally I walk into a hotel and I'm told the hotel is filled up. And I know that's not the case. So I do understand there is something there. I'm not sure it would rise to the level in a criminal trial of using it as a defense, but I think this is a conversation that is worthy of a much broader conversation.
Yeah. The one good thing about it is it helps you to identify what some minority groups are going through.
Right.
If I may,
No.
Mr. Chair, to your example, I think that one thing we could look at to distinguish that situation from what the bill's covering is the immutability of the identity that we're talking about, right? That we're talking about orientation or gender expression or identity. And that's something that society has grown to accept as something that's inherent to a person. I can, if I'm in a motorcycle gang or if I wear certain clothes, I can take those clothes off. But you can't necessarily take off your religion, right? If I'm somebody who wears hijab or niqab or burqa, that's an outward expression of my religious beliefs. It's something that I wear as an edict, as a mandate, right? I can't take off my brownness when I go out in Vermont. I live in the skin, right? So I think similarly, That's really where the difference hinges here, is your membership in a group like that is something that it's not necessarily core to your identity in the sense that your gender orientation or expression might be, or your race.
I understood that. I was trying to point out that to go much further with this bill in this session without some report back could expand to other groups. Your point is well taken.
I think the only easy thing I could point to is there is a specific list of categories that you may not discriminate in that are common. And I'm just wondering, when you use the example of religious affiliation, should that be included in this list? Personally, I feel it should be. I agree with you, Dick. There may not be enough time in the session to try to broaden it. But I wouldn't want to, if I was someone of color, for instance, this kind of limitation of it being only sexual orientation and gender identity, it just seems like it's an ideal time to bring in those categories that are traditionally protected and make a statement for society moving forward.
I would, and I know you want to move on, Mr. Chair, but I would say that, you know, the language around this is discovery of, knowledge about, or potential disclosure of. So it's trying to get at that revelation moment where somebody learns something that's not obvious from plain sight. And so in that way, I do think it's targeted. It's trying to speak to that particular defense that suddenly I learned because he put his hand on my knee or something. I learned of his gender identity or orientation. So I take Joe's point. I think it's worth thinking about, but I do think the bill is trying to narrow to an instance in the LGBTQ experience where their sexual identity, which isn't immediately apparent often, is supposedly learned about and provokes panic, which would be different than reacting to, you know, hate crime stuff where you are reacting to something you can see that someone is disabled of a certain race, of a certain gender.
If I may, Senator, I actually,
Yep.
I'd like to halfway disagree there, only because
Okay.
there are a lot of other seemingly visible attributes that a person may still end up discovering. For example, it's often my experience that people discover that I'm not Black American, that I'm Hispanic. And, you know, that might trigger a different response. There are some people who you might think are of one religion. Richard Gere is Buddhist, who knew, right? You know, so I think that there are still those discovery points that are worth thinking about, or a person who has a non-visible disability, but who may be perhaps on the spectrum or some other IDD that if and when discovered might trigger a reaction in folks. So I suppose this is possibly an opportunity to expand here. And I know that we have, you know, hate crime enhancements, and we have other laws that sort of speak to this across the various protected categories. It is an opportunity, but even if we left the bill as is, it would be an important step, not just for this community, but for all of the intersectional communities who are experiencing this as well.
Great. Senator White.
I'm just wondering if it would be easy enough to come up with some language that expands it, but doesn't expand it to the motorcycle garb, but just to protected classes. I don't know if that is easy to do. That's probably something Bryn would know, and maybe Bryn and Susanna could come up with some language and we could look at it.
All I would say is when I was on economic development, we had a bill that added one element to the protected class list, and we were working on it for a solid month because it becomes a much larger conversation. So I take Joe's point. I also take the chair's point that at this point in the session, given where this bill has been focused, I think if we try to expand it in the way that we've just been talking about, it will occupy a great deal of our time. And maybe that's worthwhile, but we do have a lot of other stuff on the docket.
We need to deal with use of force and several other bills. The House has been very active. Good thing, bad thing, I don't know. But, so I would invite thoughts about a report back about how to, are there other defenses that are being used that should be categorized in the same way. And I just did read S58, and it's very similar, although it's very different too. I mean, we could always amend the bill with S58. At that rate, I'm going to thank Susanna for joining us. I'm sure she'll be with us very near future on other issues, and I hope we're getting you some help this year, by the way, over in the appropriation side of the ledger.
Two
It
people,
appears
maybe.
that way.
Pardon
And
me?
Susanna, I did get your email. Thank you for that.
Okay, we're going to take a